At a time when abortion rights of women continue to be a point of contention across the globe, the Supreme Court of India delivered a landmark judgment on Thursday. To give you a few quick pointers, the Supreme Court has basically ruled that the abortion rights available to a rape victim under the current law would also be similarly available to victims of marital rape, that is, women who allege that they conceived because of violence or sexual violence from their husbands. The court also said that the rights available to married women under the Medical Termination of Pregnancy Act 1971, which is the current law which deals with abortions, to abort a fetus will also be available to unmarried women. But there's of course a lot to unpack in this 75-page judgment, and in this video, I, Apoorva Mandhani, will do just that for you. Okay, so let me begin with what the abortion law currently says, that is the MTP Act. So we have the Medical Termination of Pregnancy Act 1971, like I mentioned. Section 3 of this act allows an abortion to be done on the advice of one doctor up to 20 weeks for all women, including married women, and two doctors in the case of women who are pregnant between 20 and 24 weeks. But for this 20 to 24 weeks extended category, abortion is allowed only for certain categories of women. Now, what are these categories? Rule 3B of the Medical Termination of Pregnancy Rules 2003 lists down these categories. You can see a list on your screens right now. So, as you can see, the list includes survivors of sexual assault or rape or incest, minors, mentally ill women, and women who undergo change in marital status, including widowhood and divorce during an ongoing pregnancy. So just keep these categories in mind when you go through this judgment. So now what the Supreme Court's interpretation means is that women alleging rape by their husbands would also fall in this list that you saw in front of you and would be able to get an abortion beyond 20 weeks as well. And the court made some very important observations while ruling this. This judgment was passed by a bench comprising Justices D.Y. Chandrachud, A.S. Bopanna and J.B. Pardiwala. And this judgment said, it was authored by Justice Chandrachud, of course, and it said that, and I quote, married women may also form part of the class of survivors of sexual assault or rape, unquote. The court said that the word rape under the MTP Act and rules would include a husband's act of sexual assault or rape committed on his wife. This is extremely significant. So the court in a way has acknowledged marital rape. In fact, it even said that, and I quote, we would be remiss in not recognizing that intimate partner violence is a reality and can take form of rape, unquote. Now, just to clarify, we know that under criminal law, section 375 of the Indian Penal Code defines rape, defines the offence of rape, the crime of rape, but it carves out an exception for sexual intercourse between a married couple, which means that this sexual intercourse, even if it's violent or non-consensual, it does not qualify as rape if a husband is raping his wife. But the Supreme Court has now said that to get the benefit of the exception under the abortion law, that is under MTP Act, a woman need not prove sexual assault, rape or incest in a court, and that there is no requirement that an FIR must be registered or the allegation of rape must be proved in a court of law or some other forum before it can be considered true for the purposes of the MTP Act, that is, before such a reason can be used to get an abortion. Why is this observation important? This is important, extremely important, because the petitions on marital rape are currently pending in the Supreme Court. These petitions reached the Supreme Court after a two-judge bench of the Delhi High Court delivered a split verdict in May this year. Split verdict meaning that both the judges had different points of view on this, and the split verdict was delivered on petitions challenging the constitutional validity of the exception that under section 375 of IPC that I just told you about, which exempts a husband from being prosecuted for having forcible sexual intercourse with his wife. But just to let you know, the Supreme Court on Thursday did clarify that understanding rape under MTP Act to include marital rape does not mean that the court is striking down this exception under section 375 of IPC. The court acknowledged that petitions challenging this exception are pending in the Supreme Court, like I mentioned, and it is leaving that the question of the constitutional validity to be decided in those proceedings. So this interpretation of including marital rape under the definition of rape is just for the purpose of MTP Act currently or abortion law currently. Now, just to let you know briefly what was this whole case about. Basically, a woman from Manipur who currently resides in Delhi said that she was in a consensual relationship and realized that she was pregnant in June this year. However, she decided to get an abortion when she was 22 weeks pregnant after her partner refused to marry her at the last stage. Now, like I said, 20 weeks is the usual limit for getting an abortion. So, she approached the Delhi High Court because she was already 22 weeks pregnant, requesting that she should be allowed to get an abortion. And she also wanted unmarried women who have a change in their status, in the status of their relationship during the pregnancy, to be included under Rule 3B, that is in the categories of women who can get an abortion even beyond 20 weeks. Currently, just to reiterate, like I mentioned, the Rule 3B only included women who undergo a change in marital status, that is widowhood or divorce, during an ongoing pregnancy. But she demanded that since her relationship status changed during her pregnancy as well, even though she was unmarried, she should be allowed that exception. But the High Court rejected her petition on July 15th this year, after which she approached the Supreme Court. And it is on this petition that the Supreme Court has now ruled that Section 3B includes unmarried or single women as well, basically asserting that the provision must be understood as extending to all women who undergo a change of material circumstances. So this is, apart from the marital rape interpretation, this is another interpretation that this judgment gives. Basically, the court said that prohibiting unmarried or single pregnant women whose pregnancies are between 20 and 24 weeks from accessing abortion, while allowing married women who are in the same circumstances to access abortion, would violate Article 14 of the Constitution. Article 14, as we know, guarantees equality before law. So the court said that making that difference between married and unmarried women who are in similar situations and giving the right to abortion to one category but not to the other category violates Article 14. The court also said, final pointer here, it also said that Article 21 gives the same right of choice on whether or not to have a child to an unmarried woman as it gives this right to choice to a married woman. So that's another observation that the court made. It's a very significant judgment. It's 75 pages long. I've written a detailed article on this as well. I'm going to add the link to that article in the description of this video. That's all I have for you for now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.